The third step is the court process. First step here is the arraignment, when you initially go into court. This is your opportunity to plead guilty or not guilty. You will plead not guilty to invoke your right to negotiate the case for a dismissal and ultimately invoke your right to have a jury trial if the case cannot be resolved to your satisfaction. After the arraignment are pre-trials. There can be one pre-trial or many pre-trials. The pre-trials are designed to allow your defense attorney and the prosecuting attorney discuss the case and give status and updates to the court as to how the case is proceeding. Mainly, the issues that will be discussed during a marijuana DUI between your defense counsel and the prosecution is the prosecution's ability, based on the evidence they are in possession of, that can be utilized to determine whether or not you were actually impaired at the time of the drive. The stronger the prosecution feels their evidence is, the more likely they are to seek a conviction as opposed to some type of mitigated plea bargain. Also, during the pretrial phase, your defense counsel can request things such as the dispatch log. They can also request video of your actual driving or of your performance of the field sobriety test if you did decide to participate in that process. There may in fact not be video or audio that was taken by the police officer. If there is not additional discovery that can be requested, then the conversation will generally just reflect upon the disposition of the case. And after the pre-trials are completed, if neither side is willing to accept the terms offered, i.e., the prosecution is not willing to give you an offer you're willing to accept, or a dismissal of the case, the next step would be an actual jury trial. The jury trial is in front of 12 peers from the community and becomes a battle of experts. The jury trial for marijuana DUI depends almost entirely on the experts' opinions against each other. Your expert will testify based on the information at their disposal that the evidence is not suggestive of actual impairment. The prosecution's expert will testify, of course, that the evidence they reviewed is indicative of impairment based on the marijuana, or more specifically, the THC in your bloodstream. After the conclusion of the trial, if there is a positive outcome, not guilty, you'll obviously be free to leave with no conviction on your record. If you are found guilty, there is post-conviction work you'll need to do. Mainly, you'll have to do classes to get your driver's license back, to satisfy the probation terms, but more importantly, you'll have to ensure that you do not violate the terms of probation, so you can have the charges dismissed off your record by a 1203.4. This was a very brief series of videos with regards to marijuana DUI. If you have more specific questions about marijuana DUIs, please feel free to contact our office for a free consultation. Thank you. You can find us on the web at Glew Kim Law, GLEWKIMLAW.com. You can reach us by telephone, toll free 1-866-648-0004.